What we're seeing today with respect to the use of right to repair statutes, at least in California, and it's of some concern to me because what the intent was of the legislature was to allow home builders the opportunity to inspect and to repair problems at houses they built, short of litigation, and also allow the homeowners the opportunity to get the home builder out there to inspect and take care of problems short of litigation. And what we're seeing, in fact, today is a frustration of that, and I think that's also happening in other states besides California. And this is important because there's been slow developing tort reform in California in particular over the last several years. And then when you see the state legislature get together, come up with a compromise, not a perfect law, but something that is meant to meet the needs of its citizens, and it doesn't happen, you kind of wonder what's going on. But I wanted to share this because this is one of 3 or 4 trends that I'm seeing. I think that's pretty significant. We are seeing filing of lawsuits without following the requirements of SB 800. We're seeing the purpose further undermined by seeing plaintiffs' counsel send mass mailings out to communities without working with builders. We're seeing no real attempt to work with a builder to address claim defects or the opportunity to go out there. And I think this makes the entire process that much more expensive. I think that if we saw more cooperation, it would help us all. When Rose is talking about the increase in expenses, I'm finding that by frustrating SB 800, we're actually making things even more expensive than they were before SB 800, even though SB 800's purpose was to allow builders to resolve things and give homeowners an opportunity to actually come out or contact their home builders and come out. My practice is representing from large publicly traded companies to smaller builders, from mass tract homes to high-end custom homes. And this is one of the things that the builders are very frustrated about. I will acknowledge that there are some builders that just don't have the wherewithal to do the work that's required under SB 800, but we are seeing, I think, a full frontal assault on what's taking place there. Another, I think, significant trend or development, and I have to say Ken alluded to this pretty clearly, deals with bankruptcies and foreclosures and insolvencies. We're seeing situations now where it's not uncommon at all for homes to be foreclosed on. We're seeing situations where insurance companies are becoming insolvent. We're seeing situations where builders have filed bankruptcy. And we're seeing situations where receiverships are taking place in various different forms. Again, affecting almost all the different stakeholders' interests that I mentioned before. And I think it's real significant. And a number of issues, I think, come up because of this, and we're seeing these on a much more frequent basis. When Ken and I co-chaired a program, it was in 2009, this was beginning to emerge, and now I think it's in pretty much a sprint. What impact this has. No question, as a builder, I'm always looking to see what homes have been foreclosed on and what rights do they have. So the questions I have in my mind and what builders have in their mind, and no doubt Rose has strong interests, as does Ken, and that is, what rights does a homeowner have if their house is foreclosed on? What rights does a lender have who took over a foreclosed property with respect to construction defect claims? What rights does a homeowner have who purchased the house from a lender that was had foreclosed on that house? And what position is a builder in who's filed bankruptcy or can't meet its SIR? These are all real-world issues that we're seeing on a much more frequent basis than ever before. And, query, is it appropriate to be pursuing alter ego and piercing the corporate veil theories or not? We're beginning to see that more often as well, and if the entity is no longer around, this becomes a much more serious litigation than just construction defect litigation. Another, and probably the last item I just want to share in terms of what I think are significant trends is just practical considerations when you have an SIR and it can't be satisfied. Or the situation, and these are very complex, when you have a wrap policy, but they may not cover all of the houses or units in the project. So you've got a wrap that covers half a project, 200 houses perhaps, and then you've got 100 houses that are not wrapped, and the subcontractors are under a typical CGL policy. Some of them may have been involved in the wrap policy, and you may have some other ones. These make for extremely complex cases, and they seem to be now becoming more the norm than the exception.